Chief Justice, Associate Justices, and may it please the court. Good morning. My partner Arwa and I, Alondra, will be representing the respondent in the case before the court today. At this time, we will speak for 20 minutes. The Second Amendment does not prohibit states from denying a law-abiding person a license to carry a handgun outside the home. The answer to that question is an unequivocal yes. It does not prohibit states from denying a person a license to carry a handgun outside the home. We respectfully request that the court uphold the court's ruling since the beginning of the Republic and allow the land of the law, the Second Amendment, to be the rule of law. With this in mind, the United States federal government should not interfere with the rights of the United States in this issue. The strict scrutiny standard of judicial review is based on the Equal Protection Clause of the 14th Amendment, the Second Amendment, and the 10th Amendment. Federal courts use strict scrutiny to determine whether certain types of government policies are constitutional or not. Facts. The Second, 10th, and 14th Amendment. 2. Any limitations on the scope of the people's right to keep and bear arms cannot override choices already made by the Constitution. The militia preamble demands the conclusion that the Second Amendment touches on state militia service only. Or the court has not considered gun control laws unconstitutional and only the state should have the power over the militia. Arguments. The Second, 10th, and 14th Amendment. In District of Columbia v. Heller, 2018, this court said the obvious about constitutional rights. The very enumeration of right takes out of the hands of the government, even the third branch of the government, the power to decide on the case-by-case basis whether the right is really worth insisting upon. The enrichment of constitutional rights necessarily takes certain policy choices off the table. In a sense, the majority of the court clearly admitted to the case that Heller changed the Constitution because they thought that they couldn't due to the U.S. Constitution. The Second Amendment. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be interfered. Unlike all of the First Amendment rights, this is clearly not an individual right. At the beginning of the Second Amendment, which says the need for a well-regulated militia being necessary for the security of a state. Note state here is not a notion, but a state or any of the states. Similarly, by guaranteeing the right to the people, generally some that was different from other individual rights that the Constitution protects, such as those guaranteed by the First, Fourth, and Ninth Amendments. 14th Amendment. All persons born and naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor denying to any person within its jurisdiction the equal protection of laws. The due process clause can easily be applied to the petitioner's claims, an internal logic flaw that would have you apply to an USFG court to overturn a state's right, which is exactly what they are doing if they apply a collective right on an individual basis. The concept of the Supreme Court was to be arbiter of justice between disputes that would take place between states. It was not designed to be the sole judge of what is constitutional or not. 2. Any limitations on the scope of the people's right to keep and bear arms cannot override choices already made by the Constitution. From United States versus Cruikshank in 1875 to District of Columbia versus Heller in 2008, the Supreme Court held that states can impose board restrictions on firearm possessions without violating the Constitution or the Bill of Rights. United States versus Cruikshank in 1875. For gun owners, Cruikshank marked the start of more than a century of unchecked regulation by the states. The case arose during a disputed gubernatorial election between Reconstruction Republicans and Democrats in Louisiana. Both the Democratic and Republican candidates for governor claimed victory. President Ulysses S. Grant sent in federal troops to support the Republican government, but Democrats refused to acknowledge their loss. The state's nearly all-black militia gathered at the Colfax County Courthouse to prevent the Democratic candidates from assuming local offices. Members of the White League, an armed paramilitary group of white Democrats attacked and killed more than 100 militiamen. Any event which became known as the Colfax Country Massacre because the state courts would not bring murder charges against whites for killing blacks. Federal charges were brought against the White League for violating the black militiamen's right to bear arms and freely assemble. The Supreme Court overruled the convictions of Cruikshank and other White League members, arguing that the First and Second Amendment apply only to the federal government, not state or local governments, nor individual citizens. The court wrote that the Second Amendment has no other effect than to restrict the powers of the national government. The U.S. Congress was barred from restricting the Second Amendment, not states or individuals. Although states could restrict citizens' guns rights, they couldn't outlaw guns altogether. Doing so would deprive the United States of its well-regulated militia. This court held in United States versus Cruikshank that individual had no inherent Second Amendment rights. For more than 100 years, this interpretation of the Second Amendment would go largely unchallenged, and individuals' rights to bear arms would be left to the states to allow or restrict as they deem fit. District of Columbia versus Heller, 2018. The Second Amendment did not fully protect an individual's right to keep arms for self-defense until policemen challenged the District of Columbia's handgun ban in 2018. Since 1976, the district had implemented a cover ban on handguns by prohibiting residents from carrying unregistered handguns while refusing to issue any registrations. Residents could have an unregistered handgun in their homes, but it had to be unloaded or reading inoperable by a trigger lock. Under the ordinance, residents of the district could not even carry an assembled loaded gun from room to room in their own homes without a registration. Dick Heller, a D.C. special policeman, applied to register a handgun he planned to keep loaded in his home. The district refused, and Heller filed suit on Second Amendment grounds to overturn the ordinance. After a narrow 5-4 vote, the Supreme Court held that D.C.'s handgun ban violated an individual's Second Amendment right to bear arms for lawful purposes such as self-defense. Essentially, the Supreme Court ruled that the right to keep and bear arms is an individual right, unconnected with service in a militia. 122 years after presence, the individual interpretation of the Second Amendment finally got its say in court and won. The court's opinion, written by late Justice Anthony, was careful to make sure the Harlan decision could not be interpreted too broadly. Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever, any manner, and for whatever purpose. Scalia wrote, however, it was the court that allowed the Second Amendment to be expanded to individual rights and the right to defend a person's home or property. Forget the idea about the state militia. A well-maintained militia is needed for defense of the state. At least in 1791, then in 2018, the court ruled that they forgot about that entirely and tried to change what the founding fathers actually meant. They created the idea that it was an individual's responsibility and right. The court's decision in Heller could not be used to overthrow laws preventing felons and the mentally ill from buying firearms or allowing citizens to carry firearms into schools or government buildings. All state rules and regulations, the court ruled that only weapons in common use, like handguns, are protected by the Second Amendment, and that dangerous or unusual weapons could still be prohibited. The Supreme Court's decision in Heller established the individual's right to keep and bear arms in federal enclaves like the District of Columbia, but it did not prevent states from continuing to put blanket restrictions on firearms. 3. The militia prima was demands the conclusion that the Second Amendment touches on state militia service only. The problem here becomes that in less than 5 months after the Bill of Rights was ratified, the USFG began to change the concept of the militia and the every essence of the U.S. Constitution. Militia Act of 1792, which provides for the authority of the president to call off the militia, basically nationalizing the state militias and power that was set aside in the U.S. Constitution for the state under the 10th Amendment. The 10th Amendment, which states the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. In a sense, nationalizing the state militia was unconstitutional according to the 10th Amendment and also took out the Second Amendment by nationalizing the state militia and making it no longer mandatory for all men ages 18 to 45 to participate in the militia. This nationalization of the militia takes out the Second Amendment. For the court has now considered gun control laws unconstitutional and only the state should have the power over the militia. National Firearms Act of 1937, signed into law June 26, 1934, signed into law by President Franklin D. Roosevelt. The National Firearms Act, public law, sought to control specifically the types of weapons typically involved in organized crime and violent gangland incidents. Automatic weapons like machine guns and easily concealed but wide impact short barrel firearms, such as sawed off shotguns, as well as mufflers and silencers. Rather than banning them, they act instead place a financial premium on them and allowed tracking of them by requiring that importers, manufacturers, and dealers register and pay an annual tax. All transfers, as well as being previously owned firearms, be restricted, including the firearms identifying marks, the owner's name, address, and place of employment, and where the gun was to be kept. Any violation of the act is subject to a 2,000 fine and up to 5 years in prison. It is important to note that this law should be unconstitutional over the fact that it is based upon regulating a state right, considering that the state has not successfully challenged its grounds for the argument that laws can be created by government to modify gun rights. But the U.S. Constitution is clear here we the respect that the only ones who can do this is the state. We pray that you uphold the original intent of the U.S. Constitution and allow states to regulate or modify how they allow their citizens within their state the ability to defend themselves. On December 15, 1791, the defense was tied with the state militia. Today, the states still control an authority by the U.S. Constitution to modify this right. The USFG, though the Supreme Court, cannot do this. To rule against the respondent in this case is to rule against the Constitution. We ask you to support the Constitution and support our rights and allow the state the power that was given to them at the time of the Constitution and Bill of Rights.
What does the Second Amendment protect?
A well-regulated militia being necessary to the security of a free state. The right of people to keep bear arms shall not be infringed. What this means is that the Second Amendment protects the ability of a state to protect its citizens. Note, like we mentioned before, it clearly states state singular, not United States, which is unitary or federal. Because of such, the USFG cannot rule today against the state in this case without taking the 10th, 2nd, and the 4th Amendments. In effect, they would reverse Marbury versus Madison 1803 in judicial review itself.
Why did the framers include the Second Amendment in the Bill of Rights?
The United States was in jeopardy of being invaded by England. In fact, on August 24, 1814, a British force led by Major General Robert Ross marched to Washington. That night, British forces set fire to multiple government and military buildings, including the White House, the Capitol building, as well as other facilities of the United States government. In 1791, the standing U.S. Army was not as strong as it is today. The state militias would be in the main line of defense in case of an invasion, just like at Lexington and Concord. In the militia, the volunteers would provide their own weapon and oftentimes their own equipment. So if they would not own a weapon, they would not be able to defend the state.
What are the limits of the Second Amendment's protection?
A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. This right cannot be infringed by the USFG but may be modified by the state because of the state is in charge of the militia.
What weapons does the term arms include?
Today, the word arms refers collectively to the offensive or defensive weapons. The word meaning has changed since it was first used 700 years ago. Its definition has never restricted civilian use of military weapons, including the Second Amendment was approved. Arms comes from the Middle English and originated from the Old French armes, which meant weapons of warriors. The word dates back to 1300s. Arms also originated from the Latin word weapons arma. This word has also first used in the 14th century. On the side note, the word firearms popped up around 1640 to describe weapons that used gunpowder compared to other arms like bows and arrows. The meaning allowed for a very broad definition of what constituted arms. The Bill of Rights 1689 states that the subject are Protestants, a member of a follower of any Western Christian churches that are separated from the Roman Catholic Church, may have arms for their defense suitable to their conditions and allowed by law.
What is the difference, if any, between the verbs keep and bear?
The phrase keep and bear arms is also characterized differently today than it would have been in the late 18th century. Many scholars asserted at the time of Revolutionary War to bear arms was an idiom meaning to belong to an organized military force. Bear arms today means to carry a gun. The idea of keep went to the fact that people had to be ready at a moment notice to take up their guns and protect their home when the militia called for them to do so.
What is a militia and why did the framers refer to it in the Second Amendment?
A professional military was completely anathema to most Americans at the end of the 18th century. Even James Madison, one of the most stalwart proponents of a strong federal government, noted in a speech before the Constitutional Convention that a standing military force with an overgrown executive will not long be safe companions to liberty. The means of self-defense against foreign danger have always been the instruments of tyranny at home. The American dislike and distrust of standing armies was nothing new. It had its root in English military history. However, even more notable was the colonists' own experience with the British Standing Army. In the lead-up to the Revolutionary War, they had begun to view the British Army as a little more than enforcers of tyranny. In fact, the Second and Third Amendment to the U.S. Constitution can be understood as having been written in direct response to the conduct of the British soldiers. Not only did the British work to curtail colonists' access to arms and munitions, at the outset of the Revolution, but colonists had been forced to lodge and supply British soldiers in the Quartering Acts of 1765 and 1774. Hence, the framers of the Constitution were quick to ensure the right to keep and bear arms, as well as a provision that no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in the manner to be prescribed by law. It was their fear of standing armies that led the framers of the Constitution to emphasize the importance of the militias. During a congressional debate on the crafting of the Second Amendment, Elbridge Gerry summoned up his connection quite neatly. What, sir, is this? What, sir, is the use of a militia? It is also to prevent this establishment of the standing army, the bane of liberty.
How should courts determine if a gun control regulation is considered long-standing?
Look at the history survey done by Quan Hill, Texas State 2018. Gun laws have been in a place since 1600s. According to Spitzer, gun laws are are as old as the country. More to the point, the idea of gun laws and regulation is as old as the country. Contemporary legislation such as concealed carry or the open carry movement ties directly to America's past. Current conversations about gun control are a review of what was in place before 1934. If not more, the distribution of gun laws within states colonies between 1607 and 1934, the table shows that type of gun law, the total of number of laws, and the number of states implementing said laws. For example, between 1868 and 1899, 5 states have passed 5 laws which banned guns. 28 states passed 48 laws which instructed the carry of guns, and 9 states passed 11 dealing with manufacturing inspection.
What is a strict scrutiny, intermediate scrutiny, rational basis review?
The strict scrutiny standard of judicial review is based on the Equal Protection Clause of 14th Amendment. Federal court uses strict scrutiny to determine whether certain types of government policies are constitutional. The highest level of judicial scrutiny that is applied especially to the law that alleged violates equal protection in order to determine if it is narrowly tailored to serve a compelling state interest.
Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Concealed carry is when a person conceals a firearm, usually a handgun, in public on their person or in something that they keep close by a purse or a backpack, for example. Open carry is when a person carries a firearm that it could be a handgun or a rifle in public without concealing it.
How should the court consider the public safety implications of licenses to carry firearms?
The importance of this debate is the heart of the United States Constitution. Does the state have the right to limit the right to bear arms? And we should have shown that this right was exercised by the colonies almost 200 years before the founding of the United States, and even 1900, almost 75% of the United States of the states in the Union at the time had states laws dealing with different guns, weapons, or arms. To rule any other way in this case today is to tear up the Constitution and our rights completely.